Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Sunday. Hey, so I wanted to come on here to kind of explain some things. I don't think that my last video regarding Buzbee's motion for pro hoc vice was thoroughly explained. And so I'm kind of breaking down each aspect of the trying to gain admission, whether the attorney himself is seeking admission into that particular jurisdiction or he is trying to work up under someone, meaning that somebody is sponsoring him while he is practicing in that jurisdiction is very, very different. Um, one thing one of my pet peeves is misinformation. I don't like when it's, spread it. I don't like when people don't have, enough, instead of educating themselves. There's nothing wrong with people, explaining, how the court system works or how seeking pro hoc vice works. It's just a matter of you educating yourself before you, spread this information to the masses. And as a teacher, on my teacher side, before, if I don't know something, I will do my research. I will gain my knowledge before I present it to my adult learners. That's how I am. That's how, I've always been. It's just a blessing that I'm also a teacher, an adult educator in lieu of being a paralegal working in the federal and state court systems. So what I'm going to do is I'm going to kind of break down in the simplest terms that I can on how this process works, because there's a lot of confusion when it comes to Tony Buzbee, him seeking admission into the Southern District of New York, and the fate of the remainder of Diddy's cases. So I'm going to go ahead and share my screen. First and foremost, um, please note that Tony Buzbee is not on every single SA case that is against Sean Combs, aka Diddy. Okay. Any plaintiff can hire any attorney that they want. Okay. If we have, so I contract with several different attorneys. If somebody comes in and says they was raped or assaulted by Diddy, then our firm or one of the attorneys will take on that particular case, and they will be that plaintiff's attorney for that case. Okay. Um, so now, in the event that an attorney takes on a case, but they feel they don't have enough experience, meaning that their firm really doesn't handle SA cases, then they would find a more expert in that field, an attorney that covers, these type of cases, and they will say, hey, they will co-counsel. Okay. Um, so there are some instances like this one with the McCrary case that the plaintiff hired another firm, okay, but she wanted to hire also Tony Buzbee. Therefore, that is why he was seeking a pro hoc vice, and I'm gonna explain that in detail of what that entails. All right, so McCrary wanted to hire him so he could be co-counsel on the case. You can have several attorneys from different firms as long as they have had their admission, they're in good standing in that jurisdiction, or they're seeking admission, or they're willing to be sponsored by another firm. Okay, so I hope that is clear enough. So every case against Sean Combs is Tony Buzbee is not the lead counsel or even a counsel on that case. All right, so I hope everybody understands that. For instance, in this McCrary case, if people are using every website that you go to, you can look and see who the attorneys are. You just got to click on it. So this is for the defendant. So let me go down to the plaintiffs. So as of right now, Candace has, don't even know how to say that, Curtis, with the Mercer Law Firm. This is the plaintiff's attorney, not Buzbee's law firm. Mercer Law Firm in the state of New York, in the city of New York, is the plaintiff's attorney, their counsel, their lawyer for this particular case. Now, Candace may have decided that she also wants to get Tony Buzbee on this case. Now, however y'all feel about Tony Buzbee, that is y'all opinions. But this is not the first, I don't want to call it a class action because it's not one lawsuit, but these are not the first type of cases that he has dealt with. He also did the Me Too movement. And if you were around during the Me Too movement, y'all know what that is. If not, definitely go back and Google it. So Candace said, okay, I want Tony Buzbee's firm on my case or to assist in this case. This is the reason as to why we get to docket 49. All right. So we're going to pay close attention to docket entry 49 and 50. But before I do that, going back to what I was saying about Tony Buzbee not being on every single case, now even though it's just like the Me Too movement, he didn't see all of the Me Too cases. So just like these cases against Diddy, not Tony Buzbee is not seeing over all the cases for the SA cases. There are different attorneys. For instance, for not John, I don't even know what Doe. Oh yes, this is the John Doe case. Bloom. Lisa Bloom is the attorney for the plaintiff. Lisa Bloom, right there. She is with the Bloom firm, and that's a prominent attorney. I'm gonna go back. Let's see. For Combs versus Burgess. This is not even an SA case, but this is Michael A. and Erica Ashley Wolf. Grayson. This is the lady that won the well, her sister, I think it was a sister or sister-in-law who won the trip through the well, not a trip, the she got to go to a Diddy party in New York. She's from Oklahoma, and she went with her sister-in-law, and she got in, but her sister-in-law didn't. Ended up getting raped, ended up in the hospital. That particular case, Ariel Mitchell is her attorney. Doe versus Combs. Mark Elliott, Caraco, Nicholas, George Sadie, Antoine Curtis. So even, and here's one right here. So if we look, so all of them, so you see how you have, oh, okay. Oh, wait, hold up. Okay, so I'll take that back. So, Curtis, once again, the Mercer Law Firm. That is Jane Doe attorney. Okay. Now, any of those plaintiffs wanted Buzbee or any other attorney on that case, they have the right to hire whoever they want. That attorney just has to go through the process of either if they have a mission, then that's good in that particular jurisdiction. If not, they have two options. The first options is to seek admission into the Southern District of New York. Now, this is only for the Southern District. Each federal district has their own rules. Eastern District has their own rules separate from the Southern District of New York. The Northern District here in Texas has separate rules than the jurisdiction in the Southern District of New York. It is up to the attorney or the paralegal or the associate attorney or the legal assistant, whoever is doing this on behalf of the attorney, to ensure that they read the local rules. That's one thing I do, is I read the local rules. I don't care how familiar I am with the local rules for that jurisdiction or that court. I make sure that I go over anytime that I am completing any type of application. Why? Is because they are forever changing. One attorney has always told me for over 15 years, when I first started this, is an attorney does not like to have to go back and do anything. You do it right the first time. All right. Now, there are two ways. So, for McCray, on this particular case, he filed a his first motion to appear pro hoc vice. All right. This was submitted on the 21st. In his application, he filed his motion or petition, however you want to say it, for pro hoc vice. When you are filing, and I'll go, let me read what he did, and then I'm gonna explain the process. So he filed his motion. The uh, what would you call it? The sponsoring attorney filed their declaration. Buzbee filed his affidavit. He submitted his certificate standings. So I'm assuming he got his certificate for the state of Texas, his bar certificate. He has his certificate for the state bar of New York, and he also submitted, or he probably submitted his certificate for the Eastern District of New York and his certificate for the the Southern District of Texas. Um, and I'm assuming because he's trying to do this on a federal level, so it would only make sense that he submit his certificates for whatever federal district he's in. So obviously the Southern District of Texas and this Eastern District of New York. Okay. Now, when he did that, there was a notice. So there was a filing error. So when we file things, we have to either accept it or reject it. In this case, it was rejected. That is why we have this entry with no number here. It says notice regarding deficient motion to appear pro hoc vice. And it says a notice to refile this pro hoc vice application. The filing fee to gain admission or pro hoc vice in the Southern District of New York is $200. Now, here is what they're saying. Everybody, y'all can read. Everybody can read. That's why I was like, I'm not understanding why people are getting misinformation. It simply states that the filing is deficient for the following reasons. He is missing the certificate of good standing from the Supreme Court of Texas. He was also missing the proposed order. It goes on to state that motion must have a wet signature from the attorney seeking pro hoc status if filing using another individual's PACER account. Refile the motion as a motion to appear pro hoc vice. Attach the correct signed PDF. Select the correct name filers, attach valid certificates of good standing issued within the past 30 days, and attach the proposed order. So he has to resubmit this. He already so entry 50 yesterday, they filed the proposed order. Now, if they refiled it, the motion to appear pro hoc vice, I don't see that entry. And sometimes if you file it right then and there, it will still go under this particular envelope. We call them envelopes. So they'll say, within 3 days, like refile in 3 days to file under this particular envelope. And I'm assuming that's why they did. That's why we don't see an additional entry. but his Pro Hoc Vice application has not been approved because they have to review it. Okay. So the only way that an application can be approved is if this docket number 50 has been signed. Okay. So we gotta stop saying that stuff is approved when it's not. The only way that it is approved is if the court signs the proposed order. That is the purpose of having a proposed order. So anytime we file a motion, we're asking the court to do something. If they say yay or nay, they only say it by this, the proposed order. That's why whenever we file a motion, we file a proposed order, whether they're going to accept or they're going to deny, whether they're going to grant, whether they are going to deny. Okay? So as of right now, his application has only been submitted. It has not been approved and it has not been denied. We have to wait until we get a signed order from the judge or the court. In the event that it does not go through, they're going to say, okay, it did not go through, and they're going to terminate this filing. That's how it works on the federal level. All right. Um, People are being like, there was one question in the comments stating that, oh, how did he forget to sign the doc? First of all, there are several ways for attorneys to sign. Okay. Either and whoever's preparing the document was a paralegal or an associate attorney. I'm pretty sure he probably didn't even do this, but he or whoever did probably used an electronic signature, or they probably used I'm gonna show y'all. Let me pull up a Word document. So an electronic signature means that they probably sent it to him to sign via Adobe or DocuSign. That will be considered an electronic signature. When you're doing just like let's say they sent it to you, or not even sent it to you. Let's say that they just said, okay, add my signature. They may have a digital signature through Adobe that they use. That doesn't count. Or they may just, type it regular. But if they do, I'm gonna show y'all how they would do it. Show y'all a Word document right quick. Hopefully this is big enough for y'all. Let me just blow this up. Okay, this is what we would use, and then we will just add their name. Okay, so this is a court approved signature. So he could have signed it that way, or they could have added his signature like this. They could have sent it to him via Adobe or DocuSign, or they could have just used a digital signature. But according to what the rules, and see, whoever is preparing, and that goes back to the individual who is preparing this for him. That is why it is very crucial that whoever is doing it, you read the court local rules, because they have court local rules. If they would have went to the website, they would have clearly seen that they only accept wet signatures, and it clearly states that electronic signatures are not accepted. Okay, so it's here, right here in black and white. So that is the only reason as to why it was rejected. Because one, Anthony, remember, Anthony is the attorney. He is the lead attorney on this case. So more than likely what happened is whoever prepared the Pro Hop Vice application sent it to Mr. Curris' law firm, and that person went into Pacer and they submitted the filing, not realizing that Tony Buzbee physically has to sign the document. It has to be a wet signature. So what they're probably going to have to do is Tony Buzbee's law firm is going to have to mail the application to this law firm in New York, to Mr. Curris' law firm in New York. They're going to have to scan it to their computer, upload it, and then go into Pacer and file it. They're not going to accept no electronic copy of the signature. They're not going to take the /S/ and then the name. No. The only wet signature, the only way that they're going to be able to file the wet signature is for Tony Buzbee's office to mail the application to uh, Attorney Curris law firm, and then they will upload it into Pacer. And that is going to be a couple of days. Okay, so I hope that makes sense. So a wet signature means that he physically has to sign the application, and he's going to have to mail it. He can't even fax it because that's considered scan. He's going to have to mail it to them, and then they could go ahead, go back into this filing, and upload the application with the wet signature. That's why they were able to do the proposed order, because the proposed order doesn't require any signatures. Doesn't require any signatures. Okay. Once that signed copy of the motion for pro hoc vice is received, they will go into Pacer and they will go ahead and upload that for consideration. Now, there is a difference between a pro hoc vice and regular admission. That's the second part that I want to go through. With a pro hoc vice, a attorney in that district will oversee an attorney who is not admitted in that district. And this is the case, this is the route that Buzbee is going. Since this is in the Southern District of New York, right? He doesn't have admission to the Southern District of New York. Therefore, a Southern District of New York attorney has to oversee an attorney that wants to practice in that jurisdiction. Okay? So therefore, he had to submit. So Candace McCurry say, hey, I want to get Buzbee on this case. They said, okay. Buzbee says, I don't have, my certificate in the Southern District of New York, but I can submit a pro hoc vice. I can have an attorney sponsor me while I am representing you in the Southern District of New York. And this is the reason why you see pro hoc vice. So you can, let's say that in your particular state, so for instance, I'm going to take myself. I'm in the state of Texas, right? And I have a case in the state of Texas. But I know that there's a bomb attorney in New York that I want to represent me. But that attorney does not have a license to practice in the jurisdiction that I am currently in. So he's going to complete a pro hoc vice application. So he's going to find, so if I have let's say I have the Buzbee firm that's representing me, but I want this New York attorney to come and represent me. The Buzbee law firm will sponsor that New York attorney. That New York attorney will have to submit a pro hoc vice application. And if granted, then they could, along with Buzbee, can work on my case. That's how that works. So that is a pro hoc vice application. Anybody could do it. I don't know if you guys were with me with Krishan when she in the Oklahoma case, she had a Florida attorney working on the Oklahoma case. They had to get pro hoc vice in order, so they had to get a Oklahoma attorney to sponsor them so that way they can oversee her case from Florida. Okay, so that's anybody. That is anybody. Anybody. All right, so I hope that was an explanation for you guys. So there's two things. You have the actual admission to that district. But if you don't go, just like Tony Buzbee is admitted in the Eastern District of New York, he is admitted in the Southern District of Texas. He's just not admitted in the Southern District of New York. Now, if he does decide to do that, he would complete a normal application to be submitted. Okay? I hope that makes sense. But that's not the route he's going. The route that he is going is pro hoc vice. And y'all, it is common. This is not no rare instance or, see like, oh my God, da da da. No. If you, I don't care whether it's on the state level, whether it is on the federal level, pro hoc vice admissions are common. Okay. Anybody can hire an attorney from anywhere if they choose to do so. But that attorney, in order to work in that district, either needs to gain admissions themselves or be sponsored by an attorney in that jurisdiction. Period. Period, period, period. Okay? So I hope this was a good explanation for you guys. So, not every Diddy case has Tony Buzbee as a plaintiff's attorney. He's not even on all of these cases. I just showed you guys a couple. I just showed you guys a couple of cases. Okay? Just because this is a movement against Diddy and just because he came out with the press conference does not mean that they have to go through the Buzbee law firm. There are other law firms throughout the 50 states that handle sexual assault cases. And if they go through those, they are going to work specifically with the attorneys of that firm. Now, if they wanted to get Buzbee as a co-counsel, then they would have to either he would have to submit a pro hoc vice application or seek admission into that particular jurisdiction if he has not already done so. That's it. That's all. So the filing in the McCrary case was deficient because they needed a wet signature because they were using the Curis Law Firm's Pacer account. So it's not as if Tony Buzbee went into Pacer to submit his own paperwork. No. They are saying because the Curtis Law Firm in New York, the Mercer Law Firm, submitted Tony Buzbee's application for pro hoc vice. But because they use their Pacer account, he has to physically sign that pro hoc vice application. Okay? Then he has to mail it to them so that way they can scan it to their desktop and go through Pacer and attach the filing. That is the only way per the rules of the Southern District of New York. So for this particular case, as of right now, Tony Buzbee cannot work on this case or be co-counsel only because they have to approve the pro hoc vice application. So as of right now, they are still waiting on a copy of that signed copy from Buzbee to upload to the system. So it hasn't been received because like I said, they're going to have to mail it. And if they filed the proposed order on yesterday, I'm pretty sure that they probably FedExed the signed application to the firm so that way the firm can go ahead and upload it to the system so they don't have to wait. So hopefully by tomorrow they will upload that to Pacer. Okay. Just by him, this transact I don't even know how to say this. What happened here is not a big deal. What happened here does not affect any of the other SA cases against Diddy. None whatsoever. It is just that they needed a wet signature on the Pro Hoc Vice application. Once they receive that, they're going to upload it, and that will probably be on Monday. All the other SA cases against Diddy, Buzbee is nowhere on them because those plaintiffs have their own attorneys. Now, if those plaintiffs say that they want Buzbee on their case, then he would have to go through the same thing. He would have, because majority of the cases are in the Southern District of New York. So if that is the case, he will have to submit a pro hoc vice application for each of those essay cases that the plaintiffs are wanting him to work on. Is nothing more, is nothing less. It is just a simple technicality, all right? Administrative error. That's it, that's all. If I did not explain that in the simplest terms, please let me know in the comments below because I want to make sure that everybody understands this process, and I want everybody to understand that what happened in this case does not affect any other case. Oh, and the last thing, people are getting it mixed up about, okay, because this happened, the whole case is going to be dismissed. No, that is not what this is saying. When people read documents, they're not understanding. In the deficiency filing, if you go back to the video from yesterday, they stated that the petition for Pro Hoc Vice, okay? And then at the end of it, you know what? Before I do that, I'm going to just pull that up right quick. One thing I do teach in my GED reading class is that we have to learn reading in context. Reading in context. Hold on, let me go to Buzbee folder. Reading in context. Oh, you know what? Nope, I did put it under Diddy. Okay, let's see. Diddy. McCrary. Oh man. Hold on, y'all, because I don't want to have to go back through here. I had a folder for her. Oh, you know what? Y'all forgive me. I'm treating this like this is a alive, and that is fine. But what I'm gonna show y'all what it actually said. Yeah, I had a folder for McCrary to put all of her filings in there, but I forgot I didn't save it on here. All right, so let me reshare my screen right quick. Okay, McCrary, here we go. All right. Is where people are getting confused. So just because there was a filing, that's why they call it a filing deficiency. There was something wrong with the filing. Here, the Committee on Grievances, here and after. So in the remainder of this document, we're not going to keep saying the Committee on Grievances. We're just going to say committee has considered Anthony G. Buzbee's petition for admission of the United States District Court for the Southern District of New York. So instead of saying Anthony Buzbee's petition for admission, we're just going to call it the petition. So it was filed on January 29th, 2025. Per the committees, so instead of saying the Committee of Grievances, we're just saying the committee review of the dockets, Mr. Buzbee has appeared in cases in this court without seeking admission. Therefore, the petition is denied. So the petition that they are referencing is the petition to the Southern District of New York, his admission for that. Okay. So she stated that because he has appeared in the cases in the court without seeking admission is denied. Therefore, the petition is denied. In the event that he moves for pro hoc vice in the court in the future, he must attach a copy of this order. What this means is that he cannot just go and seek admission to the Southern District of New York. Okay? Because remember, there's two ways. Either he seeks admission to the Southern District of New York, or he goes the pro hoc vice way, where he is sponsored by a attorney in that who is already admitted in that district. So he can no longer just go himself solely and say, I want to be admitted into the Southern District of New York. And that is fine. So his only option is to be sponsored by an attorney in the Southern District who is admitted in the Southern District of New York. And that's what we see in the McCrary case. So in the McCrary case, he can't be the sole attorney, but he could be sponsored by an attorney who's already under or who has already been admitted in the Southern District of New York. All right, makes sense? So if he, so now, and then also, I just thought about this because his petition has been denied to be admitted in the Southern District, New York. Anytime he files a pro hoc vice application to be sponsored under an attorney who has been admitted in that district, he has to attach this order to let them know that he has tried. Well, pretty much he tried to get admission, but it was denied because he was already trying to appear in cases where he was, and he wasn't admitted in the district. But it's okay. None of the other cases are in jeopardy as long as he is working or being sponsored by an attorney who has admission in the Southern District of New York. He is okay. Okay? So, that's probably the most important thing that I needed to say. All right? So he can no longer try to get admitted himself solely, the Buzbee law firm, by himself through the Southern District of New York. The only thing that he can do is be sponsored by an attorney who's already admitted in that district, in the Southern District. Okay? Hopefully, I explained that clearly. If not, definitely leave your questions in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.